Court reporter, can we go on the record?
On the record at 404.
Thank you. Good afternoon, everyone. I'm IHO Mendoza, and we are here on case number 283285. The student's name is Frida, Frida, Nemon, Nemon. With me in the hearing room, I have counsel for the parents counsel. If you could put your appearance on the record.
Hi, yes, good afternoon. This is Jennifer Mateer, attorney for the parent from the law firm of Tamara Ross.
Thank you. And we do not have the district present. I'm going to go ahead and send a courtesy email to the school district letting them know that we do not have a representative present. However, we are still going to proceed with the pre-hearing conference. Just give me one moment. All right, so we are here today for a pre-hearing conference regarding a due process complaint that was filed on July 19th, 2024. On July 30th of 2024, I was detailed to preside as the impartial hearing officer in this case. So parents counsel, I'm looking at your due process complaint. This is regarding the 24-25 school year. Is that correct?
Yes, that's correct.
And is it accurate to say that the parent's complaint is that the school district failed to provide a program and placement for the 24-25 school year?
Correct, that the DOE failed to create an IEP as well as offer a public school placement for the 24-25 school year.
Okay, and the parent is requesting tuition reimbursement or direct funding?
That's correct. The parent is requesting, I don't know exactly whether it's a combination of both or just funding. I would have to double check that, but the parent is requesting funding, either direct funding and or tuition reimbursement for the 12-month 24-25 school year at the Jewish Center for Special Education.
Okay. So just so parties are aware, I am detailing this all in the pre-hearing summary and order. Since the district is not present, I'm going to give the district 5 days to assert whether they will be, to put the parent on notice as to whether they're going to assert any affirmative defenses in this case. The failure to do so will result in a waiver. Parents counsel, do you anticipate any motions in this case?
No.
Okay.
Joe, can I just confirm when you're saying that you're going to give them 5 days to indicate whether they will assert affirmative defenses? If they don't respond within that time period, then are you saying that they can't put on a prong one case, an affirmative prong one?
No, affirmative defense is as to whether they're going to assert the June 1st defense.
Well, this is a tuition case, so there would be
no sorry. Yes. Sorry, force of habit.
No problem. Can we, the parent would request that there be some sort of deadline for the DOE to be able to indicate, their position regarding whether they're going to be putting on a prong one case. I'm just.
What does the parent propose?
At this point, I believe. I'm sorry. I'm just double checking just to see if I received any sort of due process response. And it doesn't look like I did. So the parent would be requesting, at this point, the DOE should have already provided a due process response. So, 5 business days to be able to indicate whether they're going to be putting on a case.
So in my pre-hearing summary and order, it does ask if the DOE has not already submitted its due process response to do so. I'm going to go ahead and give the district an additional 5 days to indicate whether they will be putting on a case, and the failure to do so will result in a waiver.
Understood. Thank you.
All right. Okay. So moving on to the logistics of the hearing. So everything is pretty much going to be covered in the pre-hearing summary and order, which I'm going to attach to the calendar invite for the due process hearing. If there are any questions or concerns regarding what's in there or what something means, just put that in writing, CC the other party. That way we're all on the same page with regard to what's expected at the hearing. There are a few things that I would like to point out. So as the parties are already aware, disclosures are due no later than 5 business days prior to the originally scheduled hearing date. I do encourage the parties to exchange disclosures early, because if there are issues that arise with witness presence or availability, obviously if you're going to exchange disclosures earlier in the process, you can determine who needs to be present, who doesn't need to be present, things of that nature. Requests for cross-examination, I ask that they come at least 3 business days prior to the originally scheduled hearing date. If there is no request for cross-examination within that timeline, your witness may be excused and does not need to be present. I ask that the request for cross-examination include the name of the witness you're intending to cross-examine, along with how much time you are requesting, and a brief proffer on what it is that witness, what issues or topics are you going to cover with that witness. So either a short statement of expected testimony or a short proffer, whichever applies. I also ask that the parties submit, sorry, I should have said, reference the affidavits first before going into cross-examination. So I ask that the parties submit affidavits in lieu of live witness testimony. If you are requesting that your witness testify live, I just need that request in writing. Cite what your good cause is, and then tell me approximately how much time that witness you're gonna need for that witness. What else? The parties should or are expected to be ready to conduct closing arguments on the record. And then I don't know if I mentioned the compliance date in this case. 1 second. The compliance date in this case is October 2nd of 2024. So meaning I will render my decision in writing via email to the parties on or before that date. Any questions, concerns, anything that the parent would like to discuss that we haven't already discussed?
I guess just with regards to the affidavits versus live testimony, when you say that you have to indicate in writing any good cause for the request, are there certain, I guess, if the reason is more timing for getting an affidavit together, would that be something that where you would allow live testimony, or does there have to be something specific?
No, the failure to provide or to get an affidavit signed and notarized, I would not consider a good cause.
So can you give examples of good cause then that you would grant?
I mean, it really just depends on the circumstances. Off the top of my head, I can't think of anything, really, but just so that the parties are aware, failure to prepare for the hearing, I would not consider a good cause.
Well, I guess just to clarify, I'm not saying failure to prepare, but sometimes things happen where the witness gets very busy with their job, or it's like it's a timing issue. It is the beginning of the year, so sometimes there can be a lot happening with these witnesses at their jobs or school. So I just want to clarify, I'm not saying a failure to just do it, but there being a reason for it being a timing issue on the witness's behalf. So I just wanted to clarify that's what I was indicating.
Okay, I would still classify that under the same not a good cause.
Okay.
I mean, I guess I don't know why your witness would not be able to sign an affidavit prior to a long-term medical emergency or something of that nature, where they just are not unavailable for those purposes is the only example I can really think of. But being unavailable, like out of town or working, I would not consider a good cause. Any other questions, Parents Council?
No.
All right. Thank you so much for your presence and participation here today. As I mentioned, I will attach the pre-hearing summary and order to the calendar invite. If there's nothing else, Court Reporter, we can go off the record.
Off the record at 4:17.
All right. Thank you so much, everyone. Have a good rest of your day.